Hi everyone and welcome to today's webinar. My name is Jodie Hill and I am going to be talking to you today about balancing and managing poor performance misconduct issues when we're also considering mental health issues in the workplace. So I'm Jodie Hill. I'm the managing partner at Thrive Law. I'm a HR and employment law specialist with a particular interest in mental health, having had my own mental health breakdown 3 years ago. And I'm really passionate about changing the way organisations really look at mental health in the workplace, but also having some of those really tricky conversations, making sure we're doing it in the right way and being mindful of the risks associated with getting it wrong. So at Thrive, we support businesses with HR, employment law advice, but also all sorts of other areas in terms of well-being, diversity and inclusion, training, mental health. I say there's absolutely loads of stuff. So there's loads of details on the last slide. If you want to get in touch with us, be absolutely happy to speak to any of you. This is a recorded session because we had some issues recording the previous session, so there'll be no questions on this one. But if you do have any questions and you're watching this on catch up, please do drop me an email. I'd be happy to discuss those with you. So let's dive in. So we've got the Equality Act 2010 that sets out what the protection is for individuals who are protected essentially from discrimination in the workplace. And in particular, I'm going to focus on disability. And that's because mental health can often be a disability. Now, there are other protected characteristics like sex, age, race, but those aren't relevant for the purposes of this particular webinar. It's also important to remember that it's a day one right, so you don't have to be employed for a period of time. And in fact, it actually predates day one because it applies to applicants as well. So if you're thinking about a job, when you're looking at recruitment, job applications, that type of thing, it's also relevant in those circumstances to make reasonable adjustments. So what's a disability? Well, Section 6 of the Equality Act really helpfully sets out a definition, and there's so much case law on this particular definition, but what we're concerned with is the mental impairment. So that's the first thing, it's the mental impairment for it to satisfy. You don't need a diagnosed condition, it just has to be a mental impairment. It also has to have a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. And what we mean by substantial and long-term is that it has to be something that's more than minor or trivial. It has to be on a regular basis with the daily activities. So it could be things like impacting on communication, sleep. It could be concentration. It could be getting out of bed, it could be washing yourself. It doesn't have to be workplace specific. So, it's really important that you're not assuming what someone's substantial impact might be, but also considering on a day-to-day basis how it impacts on their ability to do normal activities, normal daily tasks. And the long-term element is relevant because an employee has to have suffered for more than 12 months with the adverse impact, or they're likely to suffer for more than 12 months. And that's really important because a lot of the time people will have a mental health condition that doesn't satisfy the definition for that particular reason. So let's be really mindful of who would be eligible to be protected under this particular legal definition. The second thing that you need to be mindful of is whether or not you know about the disability and the impact. So just knowing about a diagnosis or seeing a sick note doesn't necessarily mean that you know about the disability, because you need to know about the substantial and long-term effect. So that's the impact that the condition has on the individual. And as soon as an employer has knowledge, or they ought to reasonably know about someone's condition, then that's where the protection basically arises. And ultimately the employer has a duty then to ensure the individual does not suffer less favourable or unfavourable treatment because of their disability, and also that they make reasonable adjustments where appropriate. So there's a case on the slides here where we talk about, when I said it earlier, I said we ought to reasonably have known, and that's where you may not know the full impact of a condition on an individual, but you may have been alluded to it by the individual, or you may have a sick note. And then if you then dismiss them as a result, or demote somebody, or something happens, and they say, well, actually that arose as a consequence of my disability, and so I didn't know about the disability, the tribunal are likely to find, well, you ought to have known, because there was enough information. And if you didn't know, but you ought to have known, you should have actually gone ahead and done an investigation to understand, does this person act in this way because of a disability, which we'll come on to. So it's also worth bearing in mind that lots of mental illnesses and neurological conditions such as ADHD, Asperger's, dyslexia, etc., and ADHD will satisfy the legal definition of disability. They are hidden, and often employers may not know of the impact. In particular, they may not know of the impact because the individual is on medication or is undergoing therapy. And what we call this in the legal sector is the deduced effect. This is where an employee, we'd say, but for their medication, but for that therapy, what would that effect of that condition be on the individual? And that's the level in which we assess disability. So often it can be very difficult in this space because one, lots of people manage their medication through medication and therapy and actually appear fine. Obviously, they are hidden disabilities. So often, we have no idea unless someone communicates that to us. So there's an element of responsibility on the employer to make everyone aware of how they can disclose those conditions if they need reasonable adjustments, but also making sure that they are, if they are raising things and you're trying to say, well, actually, we can't see it. It might be, I don't know, like about the impact. We can't see that there's an impact. It's about more than that. It's not just about what you can see. It's about doing an investigation and understanding from a medical perspective what the deduced effect would be if they weren't taking medication or engaging in therapy. So all of this is relevant for the poor performance stuff, because obviously if they have a disability, regardless of their poor performance, they are protected from less favourable treatment. So we need to balance capability processes and misconduct processes with disability to ensure that we don't discriminate indirectly or in any way, whether there's an intention or not. There's lots of types of discrimination that are relevant. So the one that I'm going to focus on mostly today is failure to make reasonable adjustments and unfavourable treatment arising from the disability. The reason for that is they are first of all, they're pretty intrinsically linked when it comes to these types of cases where an individual has a mental health condition and is not performing or acts in a way that could amount to gross misconduct or misconduct, and the employer then proceeds to dismiss them or give them a warning. Now, that might be fair under the Employment Rights Act, but it might also amount to unfavourable treatment arising from the disability or a failure to make reasonable adjustments. So they're the two that I think come up most in this particular space, but obviously the others also do. One thing I always like to refer to when I'm talking about mental health is this quote from James Routledge. He says, if people are lying about their mental health problems to get time off, then you have some issues. You've got some big issues. Most people are good people and do not want to do that. If you, the employer, think that's what people will do, then you have some real trust issues yourself. And I say this because it's very difficult for employees to talk about their mental health at work. And so if they're saying to you, I'm struggling, this is a problem, and they need some help, then it's really important that you as an employer trust them. Now, there are always going to be people who will swing the lead. But 9 times out of 10, if someone is being open about their mental health, then yes, they usually are somebody who needs support. If it's someone that is now has never had a mental health problem before, is being disciplined, and then goes off sick with mental ill health, and they've not got any pre-existing conditions, then it's likely, as we all know, that that's a natural reaction to a stressful situation. And in those circumstances, it may well be that they're suffering with their mental health, but they're unlikely at that stage to meet the definition of disability, and you can plough on with the process that you're doing, provided that you're satisfied there's no reasonable adjustments that you could make in the circumstances. So, I completely understand there are lots of people who do, in fact, take a stance where they know that will scare the employer, so they'll say that they've got a mental health problem, but it's very, very rare. So I would like to encourage employers to trust employees when it comes to this point. So let's talk about poor performance first then. So this is where the poor performance in particular arises from a mental health condition. In this case, I've chosen dyslexia as a neurological condition. So in this particular case, The employee was a shift supervisor whose dyslexia meant that she had difficulty with spelling and comprehension of information. Her employer was aware of her dyslexia and the impact of the dyslexia. So they're fully aware of the disability. She was disciplined for making mistakes and falsifying records in relation to a requirement to log fridge and water temperatures in a duty roster notebook. The disciplining manager required proof of her dyslexia and suggested that she obtain a certificate from her doctor. No medical assessment was undertaken, and the claimant was issued with a warning. She then brought a claim for disability discrimination, and in particular, the claims were founded on the basis that the disciplinary action was unfavourable discrimination. So that's the unfavourable treatment that I talked about before under section 15, and they say it wasn't justified. So with unfavourable treatment, whilst it can be unfavourable, often the employer can justify that as a proportionate means of achieving a legitimate aim. And what that means is the employer have a defence. In this particular case, they were not able to justify it because they had failed to make those reasonable adjustments in a way that they'd basically gone through the disciplinary process. So what's really important is that, as we can see here, as illustrated from this case, is that in order to be able to justify a dismissal, it needs to be, or not even a dismissal, in this case, a warning. In order to justify any unfavourable treatment, you must have explored alternatives such as reasonable adjustments. It has to be a last resort, because if it's not, it'd be very difficult then to justify it as a proportionate means of achieving a legitimate aim, because the tribunal said, well, it wasn't proportionate. You could have done X, you could have done Y, you could have made this adjustment. So it's really important we don't dive straight to the outcome, and we ensure that we've explored, first of all, the impact of the condition, and secondly, whether or not there are any alternatives prior to making a sanction against an individual. Okay. Misconduct now. So misconduct case, here we go. So in this case, we have an employee. This is the case I referred to on the first couple of slides when we talked about the definition of disability. In this particular case, Mr. Nally had worked in a care home for elderly residents for 18 months, and two particular incidents arose during that period of time. The first incident, he told a resident to shut up, and having explained to his employer that he had post-traumatic stress disorder, he was told his performance would thereafter be monitored. 2 weeks later, he argued with a work colleague. As a result, he was then dismissed. The tribunal concluded that the employer had been put on notice. And what we mean by that is on notice of his mental health condition, i.e. they had imputed knowledge of his disability, and that they should have been aware that his behaviour could have been because of his PTSD. Rather than moving to dismiss the claimant, the decision should have been delayed while other steps were taken, including an investigation into his condition and considering alternative measures to terminating his employment, such as a demotion or suspension. So again, same principle applies. Even though the two incidents were potential misconduct issues, because the employer knew that he had PTSD and because they were on notice of that, it was then their obligation to proceed and do an investigation. It was their obligation to make sure that they explored other steps were taken and alternative measures were explored. So those are two cases that, it's similar in principle, but you can see how employers might get it wrong, and obviously how these employers did get it wrong. So in terms of practicality, practical tips for me, I've got loads actually that I could share with you, but I'll go through a couple of the ones on the slides. First of all, actively listen. We have 2 ears, 1 mouth. That means listen twice as much, if not more, than you talk. And this is important because often we jump to conclusions and judgments and, they've done this wrong, or they're not performing, therefore, actually, they deserve to be dismissed, or they deserve, actually, no, you need to listen. If you listen, you may find information that you didn't know existed. You may also have a different opinion on the outcome, and you also may avoid a discrimination claim. So don't make assumptions as well. Just because you have an anxiety, I've got anxiety, I've got ADHD, I don't assume that someone with the same conditions manifests in the same way. you shouldn't do that either. Equally, if you've managed someone and they didn't react that way because they had PTSD, therefore it's got to be a lie, don't make those assumptions, because that can get you in really, really hot water. Always think, could their conduct be because of a disability? Is there anything that makes you feel that it could be, or could their performance be because of a disability? So in that situation that we just talked about on the previous slide, in the Nally case, we knew that he'd already told them that his behavior was because of that, and then it was being monitored. So, you know, in those circumstances, encourage your staff to keep a record of all of the incidents that occur. If someone has disclosed a mental health condition, whether it's formal or informal, make sure that's on the file so that the investigating officer is aware before a decision is made. If you're not sure, but you have an inkling and you have some form of clue, or they've alluded to it, but you're not sure of the impact, then make inquiries, make sure you do a proper investigation and get experts involved, get health involved, get GP, psychiatrist, whoever's treating them involved, and try to understand before you make that decision. Follow up with your company policies. I can't stress this enough. It's really important that employers actually follow their own policies and procedures, but also adjust these if they need to for individuals who may be suffering from a disability in the workplace. So are there any adjustments you can make to the policy? And an example of that is where an individual may have hit trigger points because of a disability, and you may want to adjust that. For example, the trigger points within a absence management policy to discount any absence for disability, or at least reduce that, so that they aren't then going straight to disciplinary or dismissal. Be alert to the possibility that there may be one or more hidden disabilities. I've just told you about the fact I've got anxiety and ADHD, and actually you may know about one and not the other. So it's really important that you create an open culture where people feel they can tell you about these conditions so that you can effectively manage them. Do not medicalize the matter. Now, what I mean by that is you do not need a diagnosis. You do not need a certificate or a doctor's letter. All you need to know is, do they have a mental impairment? And how long have they suffered from it? But actually, in reality, you don't really need to know how long. If they need adjustments, you really should be supporting them anyway. But equally, from a risk perspective, obviously you would want to know whether they meet that definition. But also, it's helpful to understand whether or not that individual needs support and adjustments in the workplace. So just actually asking the questions. You do not need a diagnosis. It's a misconception that you need that. It can, in fact, there are conditions where people believe that they have it, but they don't have a formal letter or diagnosis, but the impact is very clear. Always keep a paper trail. Your decision could be challenged at any point, and an employee can bring a claim within 3 months, but also it could be challenged by way of appeal internally, or at a later date if the employee has a warning and then goes on to dismissal. And you need to be able to objectively justify your decisions, especially be clear about illustrating how you've taken the steps, what steps you've taken, why you took them, and especially where there's a sanction. So what I mean by that is a disciplinary sanction, such as a warning, a demotion, a dismissal. So again, basic stuff, but it's really important, because if you can't objectively justify it, you probably can't defend the claim. Do not just focus solely on the employee's area of difficulty. Please consider their strengths. Often individuals will have significant strengths put into the right role, and sometimes it's the role that's not right, not them. So this, is often something we see, especially with neurological conditions. Someone with ASD may have strengths including attention to detail, accuracy, but may need a really structured working environment and routine compared to a neurotypical individual. So it's really important that you consider, is this role the right role for them, or are there certain tasks that they would be better at, and put them in a role that actually fits their skill set and their strengths, rather than focusing on the areas of difficulty. Also, keep in mind management processes. Make sure, I've seen this time and time again, management processes have a real impact on people who are anxious or depressed or have PTSD. And partly that's because it's triggering, or the stress around that can trigger their symptoms, but equally it's a stressful process anyway. So if you already have a condition, it can be incredibly stressful. So bear in mind the process and think about adjustments that you might be able to make, whether that's allowing them to do the meeting with someone that they know rather than just a colleague, or having a coaching with them or some sort of support during those meetings, and ensuring they have so much more time to prepare so that they feel that they're not being ambushed. Also keep in mind that workplace concerns, for example, a personality clash, performance concerns or misconduct may also be as a result of a hidden disability. We see it time and time again where an individual doesn't see eye to someone, and that's not because they're acting in any way in gross misconduct. It's just the way that they interpret information, and that can be because of their mental health condition or a neurological condition, because they interpret things very, very differently. So we've just got to be mindful that a personality clash might not actually be as a result of performance or misconduct, poor performance misconduct, should I say. It might actually just be because they have a hidden disability. And again, they need to be, everybody needs some training around how to take that person in the workplace. So obviously we know occupational health are super helpful in this space. Now, if you are thinking about making reasonable adjustments, or you are in a space where you need guidance on whether or not the employee is either disabled, what adjustments, whether it's whether the behavior is because of their so whether it's their performance or misconduct is because of their disability, if so, will it improve, all of that stuff, go to Simply People, have a look at their OC Health providers, and also see if there are any other third parties such as a psychiatrist or a GP or a therapist or anyone that's speaking to them at the time that can give you some insight into how to support them. So we have another case study. An employee is struggling with depression. She keeps working, but performance is insufficient. The employer should discuss how to assist, refer to occupational health, and explore reasonable adjustments. The employer can still discuss performance, but should consider the impact of the disability on their performance and adjust targets and support where reasonable. So it's important that you can consider proceeding with all of your processes, but it's about making sure that, first of all, we acknowledge whether there is a disability and get support externally if needed, or internally, on how you might be able to assist that person, and then continue to have those conversations in a really structured format, so that the individual knows exactly that what's happening and what support they'll get. So this is an absolute corker of a case. It's still ongoing. In McKenzie and AA Insurance, the CEO of the organisation punched a senior colleague at a social event. He actually said that he has GAD, which is generalised anxiety disorder, and depression, and that all of this had been brought on by months of overwork. 4 days after the incident, his psychiatrist, in fact, raised the fact that he actually did have created a report specifically discussing the impact on this particular individual, and he specifically reported that the CEO had anxiety, sleep disturbance, concentration loss, forgetfulness, increased emotionality, and reduced emotional self-regulation with irritability and outbursts of anger. These symptoms could have been the consequence of a progressive neurological illness, but the symptoms could also be the consequence of a toxic combination of extremely high stress levels over the last few years, including feeling completely undermined by his executive colleagues and taking on reasonable levels of responsibility. Bob, the CEO, needs to be treated by his company as if he has had a heart attack and will be signed off for approximately 6 months. Clearly, Bob is very unwell. The argument here is the claimant, Bob is claiming unfair dismissal, and he's also claiming discrimination because he says his dismissal arose as a consequence of his disabilities, which are generalised anxiety disorder and depression. Now, it remains to be seen, first of all, whether the dismissal was unfair. That will obviously be a completely separate process, looking at whether there was a fair reason, which punching someone probably is, but was the social event in the course of employment? And secondly, whether or not the dismissal was reasonable or fair. And that's it's a very complex area, and they'll go into much more detail. What I want to focus on though is the Section 15. So Section 15 was the disability discrimination where it arises as a consequence of the disability. So he's saying, and he's got medical evidence to support that he has outbursts of anger and irritability. He's saying that the punching of a senior colleague arose because of the GAD, which is the generalized anxiety disorder and depression. And on that basis, he was treated unfavorably because he was dismissed. Now, no doubt the employer have argued that it was proportionate means of achieving a legitimate aim because he physically assaulted a member of the senior team. So it remains to be seen whether or not any of his claims will be successful, and or the response from the respondent in terms of their defence will also be successful. But I thought it was a really interesting scenario. Obviously, it's quite extreme, but it's not uncommon for these situations to arise. So what are the risks if we get it wrong? Well, there's disability discrimination claims, which I've just spoke about in some detail, but particularly what's relevant here are failure to make reasonable adjustment claims and Section 15, that's the arising from claims, so the disability discrimination arising as a consequence of the disability. There's also a real risk that there could be an unfair dismissal claim, because if you haven't made adjustments, the tribunal could argue, or say the tribunal could find that it wasn't within the band of reasonable responses. There's also wrongful dismissal, because if you dismiss for gross misconduct when actually it's not, or constructive dismissal where you failed to make an adjustment or treated someone unfavorably, they then resign in response to that. So as always, employees will have 3 months to bring a claim. So it's very important that we are mindful of these time limits. Now, just because they've got 3 months, that doesn't mean if you don't hear in 3 months that you haven't, that you're off the hook. Employees have 3 months less 1 day to go to ACAS, start the early conciliation process. And once they've gone through that process, what we find is it then takes a while, and they have at least a month then once they've gone through that process. So you generally won't hear anything for 5-6 months. If you're not willing to engage in ACAS, then you wouldn't hear anything for a while. So always give it a bit of time. Obviously, tribunals are backlogged at the moment. I mean, I hope that none of you would ever end up in this situation, but if you do, we do offer free initial assessments on that. So if you are worried or you think, anything's going to happen, I mean, we'd ideally prefer to help people before it even gets to tribunal. As soon as you've got an inkling that you need to make an adjustment, that's where we help organisations get it right. We do not want to be ending up in tribunal, but equally, if we do, I trained as a barrister. I have a great litigation team, and we can also support in defending claims where you've made mistakes. As I said, we can support in lots of different ways. We provide tribunal support, but we also help individuals and companies with any employment law related queries. We also provide fixed fee HR support with all of these types of processes, which mean you've got unlimited access to our dedicated team of lawyers who can really support you with these really complex and actually quite emotionally challenging and triggering processes. So do get in touch for a no obligation quote. We'll be more than happy to help. And if you want any free employment law bulletins and updates on coronavirus and all things HR and employment law and mental health, drop me an email. My email's on the last slide, and I'll be more than happy to pop you on our database. We are super passionate about wellbeing, and on the back of the first lockdown, we created our own wellbeing platform. It's got mental health champion training, which takes about an hour to complete, and it's got loads of helpful guidance and toolkits and emails and policies and initiatives for you guys to support your team with mental health. And, hopefully by supporting your team in a really proactive manner, you don't end up having to performance manage them. You don't end up having to dismiss them for, having a breakdown and smacking someone in the workplace. It's about that proactive approach. So I'd be more than happy to offer a free trial to anyone who'd like free access to complete the training. And then obviously if that's suitable for their team, then again, we can roll that out to the team. So drop me an email. I'd be more than happy to help. And finally, we've got loads of helpful information on our YouTube channel and on our website. We've got blogs and videos. If you've got any questions, drop me an email. I would be more than happy to help. We've got links in the slides. If you want a copy of the slides, email me or Danny. Again, like, follow us on social media, and I'd be more than happy to help. If you've got any questions about anything we've discussed, or you've got any suggestions for YouTube videos that you'd like me to do, just drop me a line. I'd love to hear from you. I hope this has been helpful, and thank you so much. I'm Jodie Hill from Thrive Law.